But the lower court fell far short in not striking out the remaining 7, which have no business being in the charge sheet. All the 7 remaining counts are watery, prima facie. They are dead on arrival, and they were dead on arrival, as I termed them, as dead as dodo. But instead of the lower court striking out the entire 15-count charge and allowing Nnamdi Kanu to go home a free man after the long walk, like Nelson Mandela, long walk to freedom, the lower court retained 7 of the counts. And we are here to say, intermediate court, court of appeal, strike out these remaining 7 counts, because the lower court never calmly looked at the documentary evidence we placed before it. The respondent, the federal government, the DSS, they never responded to the critical issues we raised, that Nnamdi Kanu was forcefully abducted in Kenya and tortured and forcefully renditioned to Nigeria on the 27th of June 2021 against the provisions of the Terrorism Prevention Act, under which he is being charged, against the provisions of the Extradition Act, against the provisions of the African Charter on Human and People's Ratification Act, Rights Act. And the law is that when you want to take a person from another country like Nnamdi Kanu from Kenya, you have to go through a certain extradition procedures. If you don't, the detaining authority, that is Kenya, have to first give you consent or permission that you can take away this subject from our jurisdiction. Kenya did not do that. In fact, Kenya said, we never told them to take Nnamdi Kanu away from here. So what the government did was to apply brute force, Vietnamese, in a most savage manner by capturing Nnamdi Kanu the same way the federal government had done against Umaru Diko, who was Shagari's minister. And we have cited several cases before the court in other jurisdictions to show that a person you have brought in forcefully cannot stand trial on counts that were existing before you brought him back, which did not amount to the offense you are now saying he has committed. And by the way, the Federal High Court Act, the Administration of Criminal Justice Act, and Supreme Court and Court of Appeal decisions say when you are charging a person for a criminal offense, you must state with particulars the place where he allegedly committed the offense, the time, the venue. But in this case, all the remaining 7 counts, they are saying, 6 of them, that Nnamdi Kanu made certain broadcasts. Broadcasts from where? From the spirit world? You did not tell us. From Ghostland? You did not tell us. And you know what they did? That was because in our earlier objection to the first charge, where they said he made the broadcast from the United Kingdom, they tried to run away from that by now saying he made the broadcast without stating where he made the broadcast from. And the law is that you cannot charge a person in such a vague and evasive manner. The Federal High Court does not have global jurisdiction over crimes allegedly committed in other parts of Nigeria. The only count that they mentioned a venue was one of the counts where he where he was accused of importing a transmitter and that it was accosted at Obolo Isuzo in Ihiala local government area of Anambra State. Of course, Ihiala local government area of Anambra State is not within the jurisdiction of the Federal High Court, such as to preside over the matter against Nnamdi Kanu in that respect. There is another point also, which is that he is being tried for allegedly committing these acts as a member or leader of IPOB. Because according to the federal government, IPOB has been banned or proscribed. Meanwhile, we have since filed an appeal against this proscription. And the appeal is pending, is extant before the same court, at the Court of Appeal. And you cannot begin to carry out a charge against a person based on a foundation which we are telling the Court of Appeal to remove. The question you should ask yourself is simple. Were Nnamdi Kanu to be tried and convicted, God forbid, and the Court of Appeal later finds out or discovers that IPOB was illegally and unlawfully and wrongfully proscribed, what do you do about that? So we are saying the law is that they should wait, whether the doctrine of least pendant, they should wait first for this court to determine the proscription of IPOB, whether it was lawful or illegal. And they are jumping the gun. So all in all, Nnamdi Kanu has no case against him at all. He is being kept in detention by the same DSS who investigated him, the same DSS who arrested him, the same DSS is detaining him, the same DSS is still keeping him in custody, the same DSS through the federal government is also prosecuting him. So where is the justice when you are the investigator, the arrestor, the accuser, and the prosecutor? Where is the justice? Justice is not only for the government, it is also for citizens like Nnamdi Kanu. Nnamdi Kanu has not done anything wrong. And we have been able to demonstrate in our brief before the Court of Appeal, as we did before the lower court, that Nnamdi Kanu never jumped bail. You jump bail when you voluntarily escape from trial and refuse to attend trial. But we all saw that on the 16th of September 2017, Nnamdi Kanu was with his late father, Eze Kanu, in his ancestral home in Umuahia, Afarauku, Ibeku, Umuahia, Abia State, when the federal government, using the army through Operation Python, invaded the home and killed in cold blood 28 unarmed Nigerians. Nnamdi Kanu managed to escape by providence. No. Are you saying that he should have waited for you to kill him when every evidence pointed to the fact that he was to be eliminated? And when he escaped to Israel, he quickly deposed to an affidavit giving circumstances under which he came. So he never jumped bail. This thing must be clear to the public that Nnamdi Kanu was enjoying his bail from 2015. He never jumped bail for one day until they forced him to flee. So by the grace of God, this is a case where the justice of the matter points in the direction that the remaining 7 counts charge still pending against Nnamdi Kanu before the lower court, Justice Bintanyako, will be struck out by this Court of Appeal. And Nnamdi Kanu, after the long walk, will walk into freedom and will become a free man. And by the way, it is even advisable that he walks into freedom, because as we speak today, I learned the entire Southeast is in a lockdown. Nnamdi Kanu has therefore become a metaphor for the struggle of a people the Indigo race, who are saying, according to them, under their name of Biafra, give us self-determination. Self-determination is allowed by all international conventions, even by the United Nations Declaration of Human Rights and United Nations conventions, all the various conventions. Self-determination is allowed. And he is saying, let my people go. And he never did that violently. We all saw that IPOB people were always on the street marching, blowing whistle, wearing beret. They never killed anybody until the government itself introduced violence. Today, for example, I learned the South is locked down. Does the federal government still want that? Does the judiciary want that? Let us all have peace and amity, because this country is one and it belongs to all of us. So I believe, by the grace of God, that Nnamdi Kanu will be set free by this Court of Appeal.
Thank you very much.